The order of formal proceedings. Hi, I'm Darren Findling of the Probate Pro, and we're going to examine SCAO Form PC 569. SCAO for State Court Administrative Office, PC for Probate Court. And this order, the order of formal proceedings, is exactly as the title says. It is the order following the hearing in which you have filed a petition for probate to commence a deceased probate estate. It is a formal proceeding. Now, to contrast that with an informal proceeding, which is followed with a register statement, which I've covered in another video. This is the order in which there's an adjudication by the court of the formal petition that has been filed. With all of the SCAO forms, they are given rise to, or they are created by virtue of various statutes and court rules. As you can see from the floating arrow at the bottom right corner, those statutes make up the basis of this particular order. There's quite a few of them here. They all start at about 700.3204. These statutes really have to be understood to understand how you navigate through the probate process. So we strongly urge you to work with a skilled, competent probate lawyer to guide you through this process. It's not intuitive, and there's no one guidebook you can go to make your way through the process. So again, working with a skilled, competent probate attorney is going to help ensure that you perform the process correctly, that you're able to achieve your result of getting the order entered, and of course, to ensure that you're not going to make mistakes that could get you into a lot of trouble, a breach or break of your fiduciary duties. So let's walk our way through this particular form. And again, we're happy to provide this form to you free of charge if you contact our office. The order of formal proceedings in the top left corner, you identify the county in which the probate matter is situated. Top right corner, the case number. Pretty easy. From there, you go to the estate name, the date of the hearing, and the judge. Again, information that will be readily obtainable when you file the petition for probate. The findings of the court is this next section. Now first, there's a statement under number 2 that says that the court that notice of hearing was given to or waived by all of the interested persons. Now the court rule 5.125 identifies the proper parties to be given notice. Now when you file the petition for probate, you have to of course give notice unless that notice has been waived by the interested persons. So here, this is just a finding that has occurred. Third is the date of death of the decedent and whether they were a resident of the county in which the probate is situated, or if they happen to be a resident outside of the state of Michigan, that there's an asset or an estate left in the county. So again, if they lived in another state, but there's an asset here in that county, you have jurisdiction to be able to file and commence a probate estate. Number 5 is a determination of the heirs. In a probate estate, when a petition is filed, there's generally a request to determine the heirs. Even though there may be a will in which there are devisees, the court determines the heirs as part of the process. It's generally done in the initial petition, and that's why Section 5 allows for a click box for a determination of the heirs. To understand who is an heir of any particular estate, again, watch the videos and of course read the statutes relating to this, because the statutes particularly define who is an heir of each type of an estate. The next section identifies whether the person died intestate, meaning without a will, or testate with a will. And again, this allows the court to make an adjudication on the admission of a will or codicil if in fact it's presented in the initial petition, or whether the person died intestate. Number 7 identifies that the individual upon which you're seeking is suitable for appointment. And again, this is just a statement that there's suitability under 700.3203 and 3204. Number 8 identifies if there is a will and it mandates in the will that there's supervision, you'd click that box. So again, the circumstances that relate to that supervision may have changed or not changed, and the form allows for you to identify that. In Section 8, the next click box identifies whether the will specifically directs unsupervised administration. So again, if that hasn't occurred, you don't check those boxes. In addition, there's a space for if you're seeking supervision or if the court is going to order supervision, you check the supervision and whether that's needed for the protection of the persons interested in the estate. And the persons can be the devisees, the heirs, the creditors, and so on. So this supervision issue is a really important consideration to ensure protection of the parties that can be affected by the probate administration. The next section is the order section. And this order part is the order that the court has determined following the hearing and the petition. And you'll see that almost everything in the findings is now repeated in the order. So again, I don't need to go through, but the first one is if the petition happens to be denied in the merits or withdrawn, those boxes are checked. But generally, if you're filing this, it's following a hearing in which it's been granted, and that box is checked. From there, most of it is a repetition from above, and it identifies who the court has appointed as personal representative. Now, the court may also appoint a special personal representative, and there are statutes that dictate when that is appropriate. Also, there's a determination by the court whether a bond is required, a surety bond or a personal bond, and that upon the filing of that bond, it'll allow for that person to qualify as the personal representative and ultimately get appointed. In addition, Section 14 allows for the court to identify if supervision is denied, and 15 is simply a repetition of above in which the heirs are determined. There's a spot for the judge to sign, which allows the entry of that particular court order, and then the attorney, if there's an attorney, that prepared the particular form. So this embodies the order of formal proceedings, which would occur following a petition for probate. Remember, petition for probate is followed with an order of formal proceedings. Contrast that with an application for informal probate, which is followed with a register's statement. I hope I haven't confused you with that, but it's important to understand the differences between the two. At the Probate Pro, we're passionate about everything probate. If you have questions regarding the order of formal proceedings or any probate or trust related issue, visit us at theprobatepro.com or call us at 1-833-PROBATE.